Good morning, everyone. I want to welcome everyone to our July Provider Forum, where we're going to talk about medical marijuana at work. We are delighted to have Jeremy Jernigan with us. He is the Chief Consultant and Founder of ProsperHR and the Talent and Organizational Development Manager for Bay County, Florida. He specializes in HR strategy, compliance, and workforce transformation by helping the public and private employers build stronger teams and monitor their HR systems. So with that, I'm going to give the floor to Jeremy. Just a little bit of housekeeping. If you want to put your questions in the chat, we will get to them as they come up, and then we can open it up for questions and answers. All right, Jeremy, the floor is yours.
Okay, can you see the slideshow still?
Yes.
Perfect. Okay, well, good morning, everyone. I apologize ahead of time. I've got a slight dry cough from a lingering sickness a few weeks ago, so if you hear me huffing every now and then, I'm sorry about that. But this morning, I want to talk to you guys about a couple of changes with medical marijuana that's going on in the state of Florida. I spoke on this just a few weeks ago. And there haven't been a lot of drastic changes, but there's been some more momentum building toward a drastic change that I just want to make sure everyone's aware of. So this morning, what I want to do is basically tell you about some current cases and proposed changes that are taking place at the state level, and the federal level, and then understand how to protect your agency moving forward in this gray area. Couple reminders that this presentation does not replace legal advice and is not intended to make you a subject matter expert on medical marijuana in the workplace. All I'm trying to do this morning is make you aware of your blind spots. What I hope you'll do is take this information back to your agency, to your decision makers, to your workers' comp carriers, to your legal counsel, and audit your own policies, audit the way you handle medical marijuana in the workplace, and review this information with those subject matter experts in a way that best benefits your particular agency. So where we are right now is that historically a positive THC test, whether it's a random drug test or pre-employment, used to equal a policy violation, and you could conduct an automatic adverse action, whether it's suspension, termination, or opting not to hire the candidate if it's pre-employment, and that wasn't a problem. But right now, the way things are moving in the state of Florida and federally, the courts are asking, does a positive THC test mean the employee is actually impaired? THC metabolites can remain in the body for days or weeks, up to 4 weeks in some cases, and a positive test does not automatically prove current impairment. Where this is deriving from here in the state of Florida is just a few years ago, there was an employee with the last name Giambrone who was placed on unpaid leave and ultimately fired after testing positive for marijuana during a random drug test. After being presented the suspension and ultimately termination, he had presented a valid medical marijuana card that he used to treat PTSD, anxiety, and insomnia. He was still fired. He ultimately sued. He argued that he only used medical marijuana for off-duty use. There was no evidence of workplace impairment at the time of his suspension or termination. And he argued that the county failed to reasonably accommodate his disability, PTSD, and anxiety under the Florida Civil Rights Act. A Florida judge actually ruled in the employee's favor, holding that the county improperly discriminated against him and that Florida law may require employers to accommodate lawful off-duty medical marijuana use in some situations. Now, that court case is currently going through the appellate process, but as of 2019 and 2024, when it's kicked to the appellate levels, that threw a whole new precedent in the state of Florida that says if you automatically terminate or give any adverse action to employees for medical marijuana, depending upon the circumstances, you could be in violation of a state law. So this case matters because this is the first, it's considered a landmark case in the state of Florida, suggesting that employers may have to consider accommodations for off-duty medical marijuana use. Nothing's changed as far as allowing on-duty use or impairment, but the problem is that so many employers are still treating medical marijuana or positive tests as an automatic adverse action. I hope you're catching a theme to me harping on the fact that automatic adverse actions are a red flag right now. Ultimately, the employer was awarded about $350,000 in back pay and penalties and interest on the case. Again, this is still going through the appellate process, but based upon the way things are changing federally and in other states as well, I would personally be surprised if this gets overturned. We had a case in New Jersey and one in Pennsylvania where it was a very similar situation where an employee was terminated for medical marijuana use, lawful medical marijuana use, sued the employee and won. Both these cases from both these states went to federal courts, and the federal judges ruled that the federal law did not supersede the particular state laws, which is a bit of an oxymoron, and both employees from both states won those cases. You may be thinking that based upon your particular agency or what you do, that you have safety sensitive positions and so you're exempt from all this. Well, the employee from Hillsborough County was a paramedic, which is a very cut and clear safety sensitive position. The argument that the judge made was under the Florida Civil Rights Act that employers may have to accommodate off-duty use. What they're trying to explain is that a drug-free workplace, which you're still allowed to have, you're still allowed to maintain all of that information, says that you cannot dictate how an employee handles his lawful medical use offsite. Some proposed changes at the federal level. So the federal government, the Department of Justice, has been proposing moving medical marijuana from a Schedule I to a Schedule III under the Controlled Substances Act. It went through a public opinion hearing process and is now through the formal hearing process, which started on June 29th and is supposed to end about July 15th, right about now, pending any further delays. What that means is that the medical marijuana will no longer be, or marijuana itself will no longer be considered as a drug that has no medical use and is considered as addictive as it used to be. If it moves to Schedule III, it will say that, okay, we recognize that it may have medical applications and it will make it easier for medical research to take place. That schedule change does not change any procedures you currently have for pre-employment, for DOT, or any type of federal regulations for medical marijuana with your workforce. It's just saying that they're going to make it easier to research from a medical standpoint, but that ultimately does lay the groundwork for it to be changed at the federal level for medical marijuana to potentially be lawful as well nationwide. So again, this will change by, this hearing should be finished by July 15th. And the reclassification is just a reminder to everybody that everything is changing rapidly. And so what we need you guys to do is audit yourself, make sure you're staying adaptable as laws, court rulings, and workplace expectations continue to change. So current state, what the card can do is allows your employees or your candidates lawful medical marijuana use under the Florida Civil Rights Act. The card may support a disability accommodation argument similar to the framework that the ADA allows employees and candidates as well. This may create a legal risk for automatic discipline. Again, the automatic part is what I'm trying to harp on this morning, and it may require employers to engage in an interactive process. Now, the card itself does not allow on-duty impairment, just like it doesn't allow on-duty impairment for any other type of drug or alcohol use in your workplace. It does not override safety policies. It does not automatically protect employment. It does not override federal law or DOT rules. You can still maintain drug-free workplace policies. You can conduct testing as applicable for pre-employment, random post-accident, reasonable suspicion. You can absolutely prohibit use and possession at work. You can remove employees from duty when safety concerns exist, and you can discipline for workplace impairment. I think this paints the best picture for what's changed currently as we're in this gray area, as the federal courts are moving and the legislation is being proposed to allow this to be recognized at the federal level. The only change in your process that should really take place right now, and it's imperative that you make this change, is that you do not automatically take adverse action. Talk with the employee or the candidate to consider medical use, job duty, safety concerns, and any reasonable accommodations, and make sure you document that process as well in the same interactive process method you would for any type of ADA accommodation. You can see from the Giambro and Hillsborough County case here in Florida that they didn't do that, and they got tacked with a $350,000 bill. Your decision tree may still have the same outcome as it normally would. You may not hire the employee. You may terminate the employee. You may suspend the employee. That's all well and good. What you've got to do is have an interactive process before you take those adverse actions. And that's all I've got for this morning.
Do you want to go ahead and open it up for questions, Jeremy?
Yes, go ahead.
Okay. Well, then people can go ahead and unmute and ask questions. This is not my wheelhouse, so I'm going to defer everything to Jeremy. You can shout them out or put them in the chat. And we will make this presentation available, correct, Jeremy, to all attendees?
Yes, I'll email it over to you as soon as we get off.
And it has his contact information, so if you want to reach out directly, we can do that. I know it was a lot of good information. All right, so one question in the chat: are there any recommendations regarding pre-employment screening
This is
as
Doug
it relates
Mullins.
to this topic?
Yes, so don't change your process. The only as far as requiring the employment screening, if you currently do that, I would change the language in any type of letters that you send out. For instance, one thing that we like to see is that if you have pre-employment drug testing and you have a positive test, you used to send out a letter that says, some people did, you send out a letter that says, hey, thanks for your interest. You tested positive. You're automatically disqualified from employment. If you want to try to have the test reconsidered, you can do so on your own dime, blah, blah, blah. You've got to change that language where it says automatically disqualified from employment. You still have all the power in the world to make your decisions as you want. You've just got to get rid of this automatic adverse action step. Any language regarding that, please get rid of it. And I've got samples of letters to send, or maybe even offer letters that you need to send moving forward. I'm happy to share those as well.
Great. All right. So another question: how will employers differentiate between medical use versus recreation use?
So this is the frustrating part. You really can't. That's why you've got to tiptoe right now while we're in this gray area. The way it works is if someone shows impairment at work, you need to address that the same way you would any type of medication or alcohol. If you have reasonable suspicion, test them. At that point in time, if they produce a medical marijuana card, you can have a conversation about, all right, you have the medical marijuana card. This is what you're allowed to do, but you cannot use it at work. You cannot be impaired at work. That's the reason there's been such a hang up in allowing recreational marijuana, is there's no way to differentiate the levels in your system and or the reason you're using it. This is going to be, I'll just tell you guys right now, this is going to be a very frustrating presentation because there are no hard answers to give you guys. All I can do is say, please be aware of the changes. Please have an interactive process, and please consult with your consultants, your legal counsel, or your workers' comp carriers.
Okay, so then Jennifer has a question, and I'm not sure what it relates to. She asks, is this the same for federal employees? So I guess state employees and federal, is this the same regulations and requirements?
So to my understanding, Florida, New Jersey, and Pennsylvania are kind of doing our own thing right now at a state level. The Florida judge has actually been called a rogue judge, for example. If you have questions about the federal employees, I would reach out to some type of federal employee legal counsel. They have what's called the OPM, the Office of Personnel Management. They have about 10,000 pages of documents and manuals for how their employees are supposed to be handled and processed. And I've only reviewed maybe 200 pages of that, so I can't speak to federal employees.
Okay. We have a request for sample letters. Do you have sample letters that you can send?
Yeah, I'll get that to you when I send you the slideshow.
Okay, and here we go. Will we need to provide their employees with medical papers or a card? And then kind of a follow-up is, other than a medical cannabis card, what other documentation can an employer ask for?
So you've got to be careful when it comes to asking for documentation. Your best bet, and this is another form I'll send you, is there's a reasonable accommodation request form that you can give the employee along with a copy of their job description. And you give it to them together and you say, you need to go to your physician that you're seeing for this medical marijuana card, have the completed, have the physician list specifically what accommodations need to be made for that medical marijuana card use, and have the physician tell you, because it's up to them to be honest with you and say the employee can take whatever it is they're taking, first thing in the morning, and there's no impairment throughout the day. Or the doctor may say the employee needs to take it 6 times a day, and there are levels throughout the day in which they are impaired. But the short answer to that is you need to give the reasonable accommodation request form and the job description to the employee and require they take it to their physician to be completed to give you a clear picture.
Great. And so one question is asking for the card a HIPAA violation? But then you just explained that there's certain documentation you can request.
Correct. I mean, if you're sitting there and you're asking for the specific diagnosis as to why they have the medical marijuana card, if you're sharing information that they have the medical marijuana card, that could be HIPAA violation. But if the employee tests positive and you ask them to produce documentation as to why they tested positive, so that if you need to you give a medical or a reasonable accommodation, that's fine. What you can't do is put on your application for all employees or all applicants right out of the gate and say, do you have a medical marijuana card? That's frowned upon. The only time you should be getting information about a medical marijuana card is if the employee or candidate volunteered that information to you, or they test positive, and then they give you that information after that. If they can't, bottom line is, if they test positive, and you give them this specific form that says, hey, you tested positive, here's what's going to happen, unless there's something we need to know about to work with you, and they can't give you a card, or they refuse to give you a card, they're still in violation of your drug-free workplace policy, and they can be terminated and or suspended, whatever your policies dictate at that time.
Great. So do we have any other questions? Or, and I may just throw this at you, Jeremy, do we have any other HR questions in general, since you are the guru? Don't be shy, put them in the chat or unmute, because we're ahead of schedule. I guess you've answered everyone's questions.
Okay. Again, if you take anything away from this, is that there should not be any automatic discipline for having a medical marijuana card and or positive results for THC. And please consult with whoever it is you need to consult with before you take action, should these instances arise.
Great. All right. Last call for any questions or comments. Well, then, we certainly appreciate everyone getting on. And Jeremy, thanks so much for the information. We will be sending it out tomorrow to all attendees. So I hope everyone has a great Tuesday.
Have a good one.
Thanks.